Today the topic chosen for discussion is the reference which is discussed in Civil Procedure Code 1908 under section 113 and Order 46. So generally the reference means the lower office may refer a matter to the higher office for the opinion of the higher office, or a doctor in a small village hospital may refer a case to the higher doctor or higher district hospital. So like that, usually the reference is always from lower to higher for eliciting opinion or to get the opinion on the concerned subject. ஒரு கீழ் கோர்ட்டு ஹையர் கோர்ட்டுக்கு ஒரு பாயிண்டை ரெஃபர் செய்வது என்பதற்கு ரெஃபரன்ஸ் என்று பெயர். உதாரணத்திற்கு கொஸ்டின் ஆஃப் லா, ஒரு சிவில் வழக்கில் கொஸ்டின் ஆஃப் லாவை தீர்மானிப்பதற்காக லோயர் கோர்ட்டு ஹையர் கோர்ட்டிற்கு அந்த மேட்டரை ரெஃபர் செய்யும், பரிந்துரைக்கு அனுப்பும். அதற்கு ரெஃபரன்ஸ் என்று பெயர். Now we will see under what circumstance the reference is made, who can refer the matter to the higher court. All these things we are going to see in this video. So first, nature and scope. Section 113 empowers subordinate court, that is the lower court, may refer to state a case and refer the same for the opinion of the high court, or to get the required matter from the higher court. Usually the question of law is referred. The question of law is whether the case is in accordance with the law or not. That will be the question of law in this case. Then object. The object of the reference is to elicit the opinion from obtain the opinion from the higher court by the subordinate court usually it is in non-appealable case. When the case is not appealable, then only the reference can be made by the lower court to the higher court. The opinion of the higher court, in the absence of, when it is referring the matter in the absence of question of law, and ensures validity of legislation. Apart from that, it also ensures the validity of legislation, that is whether the act, ordinance and regulation are in conformity with the question of law. Reference usually made before judgment. And next we will see the condition, under what condition the reference can be made. First one is, there must be a pending suit. The suit is not ordered, or the degree is not passed. That means the suit is pending in the lower court. A question of law must arise in the particular case of suit. So there should be a question of law is lacking, and that requires the question of law. Such is the condition of the suit. Then the court trying the suit must entertain reasonable doubt. So the lower court must have certain reasonable doubt on the question of law. So if these conditions are satisfied, then the lower court can approach the higher court for eliciting opinion, particularly on the question of law. Then reasonable doubt on a question of law. So there should be a reasonable doubt should be in the question of law. Then who may apply? Next one is, who can apply for reference. So particularly the parties to the case, or even um, the lower court may seek the opinion, or suo motu. Suo motu means on the court itself, the Supreme Court itself will take the matter. That's called suo motu. So only a court can refer a case on an application of a party, or suo motu. Suo motu means on itself. The court itself will refer the matter. A tribunal cannot the tribunals cannot refer a matter to the higher court. So this is the who may apply, the parties to the suit, or suo motu can be made. Then power and duty of referring court. What is the referring court, the lower court power? We have reference only in a suit, appeal, or execution of proceedings before a court. So only when there is a suit in the lower court, or appeal, or execution proceedings before a court, then only the reference can be made. Then power and duties of high court. What is the power and duties of high court? The jurisdiction of high court is consultative, and the power of the high court relating to reference is not confined to question of law only referred, but also if some other things are lacking, that also can be suggestions can be made by the higher court. That is, the power of high court relating to reference is not confined to question of law, then referred by subordinate court. If a new aspect arises, then the high court has power to consider it. So if a new problem arises in the particular case, that also can be taken up by the high court. So high court has the power, such a power, not only on the question of law, but also if some other matter arises on the question of law, then that also can be taken up. The case study is S.K. Rai versus Board of Revenue, All India Report 1967. Then procedure at hearing. What are the procedure to be followed at hearing? So when a matter is referred to high court, the court draw statement of the fact of case, then formulate question of law. First the statement of fact of the case, then formulate the question of law. So the court has the power to stay the proceedings, or pass decree, or order contingent upon degree of high court. Contingent means the immediate happening, that is contingent upon degree of high court on the points referred. So on the points referred by the high court, referred to the high court, the lower court can stay the proceedings, or pass decree, or order contingent upon degree of high court on the points referred. So basing upon the points referred, basing upon the high court suggestion or opinion, the lower court can stay the proceedings, or pass the degree, or order contingent upon degree. So if the high court answers in favor of plaintiff, the degree is confirmed. So whenever the high court answers in favor of the plaintiff, the degree will be confirmed. The degree passed by the higher court will be confirmed. And if it is answered against him, against the plaintiff, the suit will be dismissed. Then cost. What is the usually when a suit is made before the court, or plaintiff is made before the civil court, the cost will be there, including lawyer cost, the lawyer charge and all. So the cost of reference shall be the cost in cost. That means the unsuccessful party has to give the cost of the case including the lawyer charge. So that is called the shall be the cost and cost. So naturally the reference cost is included in the cost of the cause. That is, the unsuccessful party shall bear the cost of the case expenditure. So the successful party may get the cost of the case. This is with regard to the cost. So with all this, we conclude the video, that is the reference to the reference of the lower court to the higher court under civil proceedings, civil procedure code, under section 113 and order that is 46. So with this we conclude this video.